truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia.
So the court meets this afternoon to hear Kuwait, Lebanon, Libya, Luxembourg, Malaysia, and Mauritius on the questions submitted to it by the United Nations General Assembly. Let me one more time recall that each delegation is kindly asked to respect the 30-minute time allocation for its presentation. This afternoon, the court will observe a short break after the presentation of Libya. I shall now give the floor to the representative of Kuwait, His Excellency Mr. Ali Ahmad Brahim Al-Dafriri. You have the floor, Excellency.
Bismillah ar-Rahman ar-Rahim. Mr. President, honorable members of the court, it is a great honor to appear before you as the agent of the state of Kuwait in these proceedings. Kuwait deeply appreciates the extraordinary effort taken by the court to allow this hearing to proceed smoothly in light of the great number of participants. The current advisory proceedings are of extreme importance to the Palestinian people, Kuwait, the international legal order, and the international community as a whole. Kuwait has always advocated that peace fosters the observance of law, and vice versa. Adherence to the United Nations Charter is an indispensable prerequisite for the definitive establishment of international peace. Indeed, peaceful relations are founded on accepted rules, and as such, peaceful relations among states are based on the provisions of the United Nations Charter. These include, notably, the principle of non-use of force and the peaceful settlement of disputes. These rules apply to all states. Respect for these fundamental rules contribute to the consolidation of international peace. Regrettably, the above-mentioned foundational rules have not been upheld in the case of Palestine. The conflict between the Palestinian and Israel, hereafter referred to as the occupying power, is an illegal occupation conflict involving, on one side, an occupying power equipped with all military means, and the other side, an occupied nation without defensive capabilities, facing daily expulsion, human rights violation, and all sufferings associated with any occupation situation. Over the past decades, the situation between the Palestinians and the occupying power has been extremely tense, resulting in a serious human rights law and humanitarian law violation committed by the latter. Various intergovernmental and non-governmental organizations have documented these violations by publishing comprehensive reports. This climate of violence compromises any possibility of reasonably discussing the issue at stake. This is further exacerbated by the recent development in Gaza. The occupying power has waged an illegitimate war on the Palestinians in Gaza, characterized by numerous international law violations. The ongoing flagrant violations have been highlighted in a series of statements issued, among others, by the UN Secretary General, the UN High Commissioner for Human Rights, and the special procedures of the UN Human Rights Council. The unprecedented violence in Gaza is a result of 57 years of illegal occupation of the Palestinian territories, and it must stop. The late Emir of the State of Kuwait His Highness Sheikh Sabah Al-Ahmed Al-Jaber Sabah, Mr. President, summarized the situation in 2018 by stating, we asked the whole world by stating, quote, Mr. President. Quote, why do we ignore and do not implement Security Council resolutions? Why? We ask the whole world. Why the Palestinian people plight continues? Why the international community incapable of resolving this cause? Why does the victims continue to be portrayed Why does the victim continue to be portrayed as a killer according to Israel's norms? Why does Israel always escape punishment? Why have all these souls been lost amid absence of world conscience? Unquote. Sorry, Mr. President.
Sorry.
Mr. President, distinguished members of the court, it is in this context that Kuwait appears for the first time before the court, following the adoption by the UN General Assembly of resolutions 77247, requesting the court to deliver an advisory opinion on two legal questions. The first question asks the court to evaluate the illegality of the occupying power's specific policies and actions within its occupation of the Palestinian territories, while seeking the court's determination of the corresponding legal ramification. The second question addresses the core issue. Has the occupation become illegal? Kuwait will demonstrate the illegality of this occupation, underscoring the necessity of its cessation. Mr. President, honorable members of the court, my distinguished colleagues will now address these issues in greater depth. Second, first, His Excellency Ambassador Tariq Al-Bannai, permanent representative of Kuwait to the UN, will address why the court does have jurisdiction to deliver the advisory opinion requested by the UN General Assembly. He will also highlight certain legal practices and policies of the occupying power. Second, Her Excellency Tahani Al-Nasser, Assistant Foreign Minister for Legal Affairs of Kuwait, will start by enumerating the grounds proving the illegality of the occupation of the Palestinian territories, hereafter referred to as the OPT. She will then focus on the legal consequences arising from the breaches of those fundamental rules. And finally, she will provide the court with a certain concluding remarks. Thank you, Mr. President, honorable members of the court, for the privilege of appearing before you. I now kindly ask Mr. President to invite Ambassador Al-Bannai to address the court.
I thank His Excellency Mr. Al-Dhafiri. I now give the floor to His Excellency Mr. Tariq Al-Bannai. You have the floor, Excellency.
Mr. President, honorable members of the court, it is a tremendous honor and privilege to appear before you on behalf of the State of Kuwait. 20 years have passed since the seminal Wall Advisory Opinion. Today, in these current proceedings, the question of the illegality of the occupation of the Palestinian territory is directly before the court. With your permission, I turn now to my first topic, focusing on whether the court has jurisdiction to render the advisory opinion requested. In Kuwait's view, the answer is a categorical yes. Indeed, the majority of submissions in these proceedings argue in favor of the court's jurisdiction. Article 65 of the Statute of the Court provides that the court may render an advisory opinion, and I quote, on any legal question at the request of any organ or institution authorized by the Charter of the United Nations or in accordance with its provisions to request such an opinion, unquote. In turn, Article 96 of the UN Charter, quote, the General Assembly or the Security Council may request the International Court of Justice for an advisory opinion on any legal question, unquote. In practice, it is primarily the General Assembly that has most frequently utilized this procedure to date. After all, when the General Assembly decides to request the court to deliver an advisory opinion, this means that the request reflects an important concern of the international community, seeking a legal answer. The court itself observed that the General Assembly, within the scope of its peacekeeping responsibilities, has a broader perspective than that of the Security Council, as it also considers humanitarian, social, and economic aspects. An attentive look at the court's jurisprudence points to the fact that, quote, only compelling reasons may lead the court to refuse its opinion in response to a request falling within its jurisdiction," unquote. Although the court has the discretionary power to refuse to respond to a request for an advisory opinion for reasons of judicial propriety, it has not availed itself of this option thus far. In the present case, it is incontestable that the questions included in the relevant General Assembly resolution are clearly specific questions of legal character. Any attempt to qualify them as non-specific or non-legal should fail. It is worth noting that the Court, in the Wall Advisory Opinion, rejected similar attempts. In essence, in the Wall Advisory Opinion, the central issue revolved around the construction of the wall and its impact on the right to self-determination of the Palestinian people. 20 years later, the context has broadened substantially. The Court is now tasked with determining the legal status of the ongoing occupation of the occupied Palestinian territory since 1967, given its persistence for over 57 years. Prior to addressing the next topic, I feel compelled to briefly refer to an argument certain states have made, fallaciously alleging that the issuance of an advisory opinion might undermine ongoing negotiations and peace processes. This argument, Mr. President, honourable members of the Court, is groundless and without merit. Kuwait has always underscored the importance of resuming peace negotiations with a view of reaching a just and comprehensive peace, based on the terms of reference of the peace process, the resolutions of the Security Council, and the Arab Peace Initiative. However, the relevant UN resolutions and the Wall Advisory Opinion make clear that any negotiations that take place must have as their objective the achievement of a just and lasting peace in accordance with international law. The Court has an important role to play in this regard by stating what the applicable rules of international law are, including the rights and obligations of the relevant parties, all states and the United Nations. This is exactly the purpose of the UN General Assembly resolution requesting the Court to deliver an advisory opinion. By doing so, the Court may in fact help revive negotiations and inspire a return to a peace process premised on international law. After all, the Court's advisory opinions shed light on complicated legal issues, appeasing tensions, uncertainties, and potential disputes. Mr. President, honourable members of the Court, I will now address our second topic, providing you with examples of the occupying power's unlawful and egregious policies and practices in the OPT. In the interest of time, I will limit my presentation to 3 policies, which demonstrate the true nature of the illegal occupation. The first is forced displacement. The second relates to the illegal settlements on and the annexation of the Palestinian territory. And the third is discrimination at a scale and nature that amounts to apartheid. The remaining issues were discussed thoroughly in the written submission of Kuwait. In the 1948 Nakba, 750,000 Palestinians were forcibly displaced, and since then, millions more. The situation has deteriorated exponentially since the illegal occupation started in 1967. The occupying power has engaged in a forced displacement campaign against the Palestinians by demolishing their homes and confiscating their lands. Forced displacement violates international law. The occupying power is under the obligation to ensure that its operations in the OPT comply with the Fourth Geneva Convention of 1949, relative to the protection of civilians, persons in time of war, to which it is a party. Article 49 of this convention clearly prohibits, quote, forcible transfers, individual or mass, regardless of their motive, unquote, which includes forced displacements, as well as expulsions from the OPT. Furthermore, Article 53 of the same instrument prohibits the destruction of property. Finally, under Article 147, illegal transfers, destruction, and appropriation of property carried out on a large scale is prohibited. As Kuwait explained in its written submission, the occupying power has also committed other grave violations of international law, including the policy of settling parts of its population in the OPT. This unlawful policy has and continues to be deplorably promoted by the successive governments of the occupying power. Since 1967, the occupying power has embarked on an intensive campaign of colonization. Some settlements consisted of just a few prefabricated houses, while others expanded to become fully fledged small towns. In early 2023, there were around 730,000 Israeli settlers and over 280 Israeli settlements in the occupied West Bank, including 230,000 settlers in East Jerusalem. These settlements are sustained by a network of military checkpoints and restricted zones, as well as Jewish-only roads and highways, all of which limit gravely the lives and livelihoods of Palestinians and violate their fundamental human rights. Both the construction of settlements and the transfer of settlers to the West Bank and Gaza are grave violations of international law. In particular, Article 49 of the Fourth Geneva Convention, which states that, I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies," unquote. It is also noteworthy, Mr. President, that settlers in the OPT are not governed by the same laws that apply to the indigenous inhabitants of the territory. Jewish settlers are provided with special rights, facilities, and subsidies that are denied to the indigenous Palestinian population. The occupying power's policy not only supports the existing settlers, but also incentivizes new settlers. The discriminatory policies and practice also violate the sovereignty of Palestinians over their natural resources, allowing the settlers and foreign companies to exploit the water and agricultural products of the occupied land without any benefit to the occupied population. It is widely recognized that the occupying power has codified its discriminatory policies and practices against Palestinians in its legislation. Specifically, it grants rights to Israeli Jews and systematically discriminates against Palestinians. For instance, the Land Acquisition Law of 1953 facilitates the alienation of confiscated Palestinian land for the benefit of various institutions of the occupying power. Quasi-public organizations, such as the Jewish Agency, engage in material discrimination, in particular through the allocation of confiscated Palestinian land to Israeli Jews. Mr. President, honorable members of the Court, thank you for your kind attention, and may I kindly ask that you invite Her Excellency Tahani al-Nasser to the podium.
I thank His Excellency Mr. Al-Bana, and now I give the floor to Her Excellency Mrs. Tahani al-Nasser. You have the floor, Excellency.
Thank you. Mr. President, distinguished members of the Court, it's a great honor and a privilege to appear before you on behalf of Kuwait. In the written submissions, the great majority of states participating in these proceedings, along with the three intergovernmental organizations, concluded that the occupation of the OPT is illegal. Kuwait firmly agrees with this view in its written submission. Kuwait identified several reasons proving the illegality of this occupation. I will provide a brief overview of these reasons for the Court. The occupation violates a series of jus cogens norms. First, the obligation to respect the right to self-determination of the Palestinian people. The right of people to self-determination is a right clearly recognized in international law as evidenced by several instruments and as submitted by 35 states and international organizations participating in these proceedings. This is articulated in Article 1.2 of the UN Charter, which define the purposes of the United Nations, including, I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen a universal peace, unquote. The same obligations are expressed in Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Second, Kuwait joined the participants in these proceedings who have concluded in their written submission that the ongoing military occupation of the OPT is illegal because it violates the jus cogens prohibition on the use of force. Third, the occupying power, by confiscating and annexing parts of the OPT, violates the prohibition on the acquisition of territory by force. This was underscored by 38 participants in the written proceedings. This fundamental norm was incorporated into Security Council Resolution 242 of 1967 and reaffirmed in Security Council Resolution 338 of 1973. Accordingly, the occupying power does not have the right to claim sovereignty over the OPT occupied since 1967. Fourth, the occupation is illegal because it obviously violates the law of military occupation. For instance, the occupation of the OPT is not of minimal duration. Facts clearly demonstrate that it is intended to be prolonged and ultimately permanent. A permanent occupation constitutes a serious violation of international law based on the verifiable evidence available to us. It's indisputable that this is precisely what is happening in the OPT. This prolonged occupation and identified violation of the Palestinians' right to self-determination renders the occupation illegal. Moreover, the conduct of the occupying power in the OPT violates the rules of international humanitarian law. In the World Advisory opinion, the Court stated that, quote, the Fourth Geneva Convention is applicable in the occupied Palestinian territories, unquote. The Court also determined that the Hague regulations are reflective of customary international law and thus applicable to the conduct of the occupying power in the OPT. Far from complying with the law of occupation, the actions of the occupying power disregard international law. These actions include, inter alia, the establishment of settlements in the OPT, confiscation of Palestinian public and private property, and its failure to protect Palestinians from violence caused by state actors and private parties, including, inter alia, armed illegal settlers. Finally, the occupation violates the jus cogens prohibition of apartheid. 21 participants in these proceedings supported this in their written submissions, while 14 maintained that the situation of apartheid qualifies the occupation as illegal under international law. The prohibition of apartheid is evidenced in various sources of international law. The occupying power is bound by the 1965 Convention on the Elimination of All Forms of Racial Discrimination, to which it is a party. Furthermore, it shall abide by the prohibition of apartheid as enshrined in 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, which codifies customary international law. Several voices and independence experts have warned that the occupation of the OPT amounts to a regime of apartheid. For instance, in March 2022, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967, in his report reached a similar conclusion. Kuwait, respectively, suggested that the above violations cannot be reconciliated with the fundamental rules of international law. Hence, the occupation must be declared illegal in accordance with international law and the relevant UN Security Council resolution. It must stop. This will guarantee the right of the Palestinian people to be available state and along 1967 borders with East Jerusalem at its capital. Mr. President, members of the Court, the legal analysis of the question involved in these advisory proceedings demonstrate that the occupation of the OPT is illegal, in contravention of the fundamental rules of international law. It is written submission, Kuwait did address the legal consequences arising from the occupying powers, numerous and long-standing violations of these rules. Please allow me to provide with a view d'ensemble. As indicated, the action of the occupying power and the occupation as a whole are plenarily incompatible with the rights of the Palestinian people and obligations of the occupying power under international law. Its breaches of these rights and obligations engage the occupying power's international responsibility. The occupying power must therefore take several measures. First, it must provide Palestinians with relief in accordance with the principles of customary international law on the responsibility of states for internationally wrongful acts. This must be achieved through the immediate cessation of its illegal occupation. Second, the occupying power must give assurance and guarantees of non-repetition of its international law violations. The occupying power shall commit itself to not repeating the same breaches in the future. Finally, the occupying power is under the obligation to make full reparation for the injury caused by its occupation and discriminatory policies and practices. As for all other states, they are obliged to refrain from acknowledging the legality of the situation created by the illegal occupation and associated illegal policies and practices. They shall also abstain from offering support or assistance to sustain the circumstances stemming from the unlawful occupation and associated actions. Third state shall also contribute to safeguarding the Palestinian population against war crimes, genocide and crimes against humanity, and ensure that those responsible for crimes committed within the framework of illegal occupation are held accountable. In turn, the UN shall refrain from acknowledging the legality of the situation resulting from the illegal occupation and associated actions. The UN shall also refrain from offering support or assistance to prolong the situation and should instead cooperate to bring an end to the illegal occupation. Mr. President, honourable members of the Court's advisory opinion is now more than ever necessary to put an end to the illegal occupation of the OPT. Kuwait has sought to concisely summarize the grounds for finding that the occupation is illegal as a whole, and submits that each ground of illegality shall form part of the Court's dispositif. We are confident that the Court will assess Kuwait's written submission and oral statement as an expression of its faith in justice, its support for the rule of law and its desire for peace for all states in the region. Mr. President, honourable members of the Court, this ends Kuwait's oral statement. Kindly allow me, on behalf of Kuwait's delegation, to thank the Court for its kind attention, as well as the registry staff and the interpreter for all their support. Thank you very much.
I thank the delegation of Kuwait for its presentation.
I now invite the next participating delegation, Lebanon, to address the Court and call His Excellency Mr. Abdel Fattah Issa to the podium. Excellency, you have the floor.
Monsieur le Président,
Mr. President, distinguished members of the Court, it is an immense honour for me to speak to you after having set out Lebanon's oral comments regarding the legal consequences arising from the policies and practices of Israel in occupied Palestinian territory, including East Jerusalem. Now, this is a subject of the greatest importance for my country and for, indeed, the entirety of the international community. The record number of requests to intervene before your esteemed court is the clearest proof of this. Having set out in writing the views of Lebanon on the different legal aspects of the questions posed, and in order to comply with brevity instructions, I will restrict myself to 3 points which have gained in importance given the seriousness of the events which have taken place since October on Palestinian territory. These 3 points are: 1, the propriety of the court's intervention; 2, peremptory nature of the norms of international law breached by Israel, specifically the prohibition of the use of force and the right to self-determination; and finally, the legal consequences arising from these violations. Now, looking at the propriety of the court's intervention, distinguished members of the court, Mr. President, we are but a few months away from the historic 20th anniversary of your opinion regarding the building of a wall in occupied Palestinian territory. Now, certain states had suggested during those advisory proceedings, as they indeed do today, that the court shouldn't give an opinion because that intervention by the court might block ongoing negotiations between the parties, might even render more difficult or even impossible the necessary political accommodation. That's a roadmap to be followed. Well, here we are, 20 years later, down the road without any negotiated solution, no negotiations at all, in fact. However, what we do have are thousands of deaths and a massive destruction of civilian infrastructure. To ask the court to not intervene, to not hand down an advisory opinion because there's a bilateral negotiation process that needs to be protected, some sort of political solution that needs to be preserved, is a perverse argument which faces politics and the law off, one against the other, whereas in all societies, including international society, these are two dialectically related complementary elements. The law is the framework which prevents political slippage, be it public or private level. It is the law which guarantees a minimum of justice in relations. Madame Chemelier-Gendreau, in 2004, clearly described this, pleading before you. I'm going to quote her now. The political sphere represents the clash of subjectivities between society's different protagonists in a direct process which produces an unmitigated balance of power. The legal sphere represents the transposition of that clash of subjectivities by reference to a pre-established standard, the legal norm, under a third-party authority offering guarantees of objectivity. Comparison with the reference norm by an impartial third party provides the prism of objectivity through which the factual situation can be rectified. End of citation. This objectivity, distinguished members of the court, it's this objectivity which we have come to seek yet again from you. Now, allow me now to move on to the second point, which relates to the peremptory nature of norms breached by Israel. As we've already mentioned in our written comments, the concept of peremptory norms has become clearer thanks to the hard work carried out by the ILC as of 2016. Talking of the work of the Commission, let me respond to comments made by certain states who would that the draft articles and conclusions of that Commission should not be considered as established concepts. This observation, distinguished members of the Court, minimises the role that this body plays on behalf of the UN General Assembly in the development and codification of international law. Let me invite the Court to examine this comment of mine regarding that in light of Article 38 of your statute. Coming back to peremptory norms, the Commission had established a non-exhaustive list of 8 peremptory norms. When Lebanon submitted its written statement, it considered that Israel had breached at least 4 of these, 4 of the 8. Since then, and given the horrors to which Palestinians in Gaza are subject, Israel is accused of breaching a 5th norm of the 8, and it's not the least, the prohibition to genocide. And this is historical irony at its saddest. As I said at the beginning, I will limit myself to two peremptory norms mentioned in our written statement: prohibition of the use of force and the right to self-determination. The justification of this choice seems obvious to me. The breach of these two norms by Israel is the indirect or direct cause of the violations of the other norms mentioned in our written statements, be they norms of international humanitarian law, human rights, or prohibition of apartheid. Were Israel to cease its occupation of Palestinian territory, including East Jerusalem, and accept the right of the Palestinian people to self-determination, all the other violations would disappear. Let me add in this regard that in the written and oral statements of many states, they refer to and even insisted upon the prolonged character of the Israeli occupation, to characterize it as an illegal annexation of Palestinian territories. Now, this is a valid and correct argument, Mr. President, but it should be taken as forming part of aggravating circumstances of the crime and not the crime itself, because the crime is one of aggression. Indeed, since 1945, the use of force under international law is strictly regulated. Since 1967, Israel has been committing a crime of aggression, illegally occupying territories before annexing them. In other terms, the occupation of territories resulting from an illegal use of force is itself illegal, however long it lasts. So, there we go. That's the first peremptory norm violated by Israel. Now I move to the prohibition of the use of force. The prohibition of the use of force is one of the peremptory norms well established, and it's clearly set out in Article 2, Para 4 of the UN Charter, which stipulates, I quote, "All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations." In 1974, the General Assembly adopted, in Resolution 3314, a definition of aggression, which enumerates non-exhaustively a number of ways force may be used illegally. According to the Annex to Resolution 3314, aggression is, I quote, "any military occupation, however temporary, any annexation by the use of force of the territory of another state or part thereof, the blockade of ports or the coasts of a state." So, Israel's occupation of Palestinian territories, its blockade of the Gaza Strip, all of this are acts of aggression. This has been a finding noted time and again by the UN Security Council, which has ceaselessly demanded since 1967 that Israel puts an end to its occupation. The General Assembly, for its part, is more explicit in its condemnation of Israeli occupation of Palestinian territories. Recently, it declared, for example, the inadmissibility of the acquisition of land by force, and therefore the illegality of the annexation of any part of the occupied Palestinian territory, including East Jerusalem, which constitutes a breach of international law. The Court, for its part, has always asserted the unlawfulness of the use of force and acquisition of territory thereby, including in its advisory opinion on the wall, where the Court also recalled the customary character of this prohibition. Now, some may question the application of the norm prohibiting the use of force on the basis that it's an interstate norm, but that would imply that the OPT are not part of a state. Well, to that, distinguished members of the Court, you can respond that Lebanon, indeed, more than 140 member states of the UN recognize the state of Palestine and East Jerusalem as its capital. The State of Palestine is a member of a number of international organizations, UNESCO, OPCW, OIC, League of Arab States, PCA et al. And Palestine is also an observer member of the UN, whose Secretary General, Mr. Guterres, declared less than a month ago that the right of the Palestinian people to build their own fully independent state must be recognized by all, and any refusal to accept the two-state solution by any party must be firmly rejected. So this really would be an expedient moment for the court to give its opinion on this point. In any event, Mr. President, distinguished members of the court, the prohibition of the use of force is not limited under international law to relations between states. Any use inconsistent with the principles and purposes of the UN Charter. Now, Israel continues its occupation and its policies, which are clearly aimed at annexing Palestinian territories. They encourage settlements, confiscation of land, destruction of public buildings, private buildings, in order to render its presence an irreversible fait accompli. And this despite all the successive resolutions of the Security Council, starting with Resolution 242. Now, in light of the foregoing, Lebanon requests the court to consider once again that Israel is breaching the fundamental principle of the unlawfulness of the use of force and its corollary, the illegality of the annexation of territories by force. Moving now to the right to self-determination. Lebanon considers that the right of the Palestinian people to self-determination is irrefutable, and there are no more eloquent words than those employed by your court to assert this reality. I quote you. The court observes that the existence of a Palestinian people is no longer an issue, and that those rights include the right to self-determination. End of quotation. The right to self-determination is a peremptory norm of international law enshrined in a number of texts, including the UN Charter, and which establishes this right as one of the foundations of friendly relations between nations. That foundation of modern international law has many facets, and Israel has violated all of them. In its advisory opinion, the court examined the legal effects of the separation of Chagos archipelago from Mauritius in 1965. They looked at the nature and the contents of the right to self-determination. And you recalled that the right to self-determination is a customary rule, and that the resolution of the General Assembly 1514 had a declaratory character. This resolution, adopted in 1960, was one of the first texts to define the contents and scope of the right to self-determination, namely that self-determination of peoples implies that they can freely determine their political status and pursue their economic and social development. The resolution also mentions that all armed action or repressive measures of all kinds directed against dependent people shall cease in order to enable them to exercise peacefully and freely their right to complete independence, and the integrity of their national territory should be respected. It also clearly indicates that any attempt aimed at the partial or total destruction of the national unity and the territorial integrity of a country is incompatible with the purposes and principles of the UN Charter. Moreover, Article 1, shared by the ICCPR and the ICESCR, asserts as well the right of peoples to self-determination, and rehearses the main constituent elements of this right. As I pointed out earlier, Lebanon considers that Israel is breaching all the constituent elements of the right of the Palestinian people to self-determination, which, 1, political and economic independence, 2, permanent sovereignty over its wealth and natural resources, and 3, territorial integrity. Israel's prevarication over the decades, despite all the agreements they concluded and the appeals of the international community to recognise the independence of the Palestinian state, is an ongoing violation of the first element of the right to self-determination. Israel's policy of confiscating agricultural land, exploiting water and mineral resources of OPT is a continuing violation of the second element, which constitutes the right to self-determination, namely the permanent sovereignty of peoples over their natural resources. The third constituent element of the right to self-determination, territorial integrity, was recalled by the court when you declared that the right to self-determination of the people concerned is defined by reference to the entirety of a non-self-governing territory, as stated in the aforementioned paragraph 6 of Resolution 1514. The court considers that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. But Israel, by its policy of colonization and construction of infrastructure linking the settlements, gnaws away at Palestinian territories, including Jerusalem. This systematic and continuing infringement of the integrity of the Palestinian people's territory is documented by a number of reports for international inquiries. So, Mr. President, we arrive now at the third point, the legal consequences of Israel's violations. The preceding points show that Israel continues to breach peremptory norms of international law, norms which create erga omnes obligations. The court already noted in its advisory opinion back in 2004, where you declared that amongst the international obligations breached by Israel were erga omnes obligations. Such obligations, by their very nature, concern all states, and given the importance of the rights in issue, all states may be considered as having an interest that these rights be protected. The nature of breached obligations entails a specific responsibility for Israel, but also a responsibility for third states. Indeed, the systematic and continuing character of the policies and actions of Israel lead to an aggravated breach which entails three types of obligations for states according to Article 41 of the draft Articles on State Responsibility recommended by the UN General Assembly in 2001. I'm going to look at those, how they apply to Israel and how they apply to third states. So, legal consequences vis-à-vis Israel. As I mentioned earlier, Israel is committing serious violations of public international law according to the definition of Article 41 of the draft Articles on State Responsibility for Internationally Wrongful Acts. As these violations are both continuous and systematic, Israel is held to seize these unlawful acts and to offer assurances of non-repetition according to Article 30, draft Articles on State Responsibility. Concretely, Israel, in this case, has to respect the principle of the prohibition of the use of force and its corollary, the inadmissibility of the annexation of territories. It must dismantle the settlements in occupied Palestinian territories and withdraw therefrom. The court had already asserted in its judgment on the legal consequences of the building of a wall in OPT that Israel must thus restitute the lands, the orchards, the olive groves, and all other property seized from any physical or legal person. Israel is also held to cease all violations of the Palestinian people's right to self-determination, to put an end to its occupation of OPT, and to recognize the State of Israel. Moreover, Israel will remain in a legal situation just so long as it does not apply the resolutions of the Security Council which deal with the different aspects of its occupation of Palestinian territories. Indeed, distinguished members of the Court, you already said in 2004, I quote you, when the Security Council adopts a decision under Article 25 in accordance with the Charter, it is for Member States to comply with that decision, including those members of the Security Council who voted against it, and those members of the UN who aren't members of the Council. To hold otherwise would be to deprive this principal organ of its essential functions and powers under the Charter. End of quotation. Given the foregoing, we could say, distinguished members of the Court, that Israeli occupation of Palestinian territory is unlawful. It's illegal, both in its aim and in its conduct. As a consequence, Israel is obliged to unconditionally and immediately put an end to this illegal situation, which entails its international responsibility, and it must also furnish reparation. Now looking at third states. Given that the norms breached by Israel are peremptory norms, these breaches affect all states on account of their erga omnes character. Draft articles on state responsibility for internationally wrongful acts stipulates in its Article 41 that states shall cooperate to bring an end through lawful means any serious breach within the meaning of Article 40. 2. No state shall recognise as lawful a situation created by a serious breach within the meaning of Article 40, nor render aid or assistance in maintaining that situation. The Court had already confirmed these elements which fall to states in case of breaches of erga omnes obligations when you said, in the legal consequences of the wall in 2004, I quote you, given the character and importance of the rights and obligation involved, the Court is of the view that all states are under an obligation not to recognise the illegal situation. They are also under an obligation not to render aid or assistance in maintaining the situation. It is also for all states, while respecting the United Nations Charter and international law, to see to it that any impediment to the exercise by the Palestinian people of its right to self-determination is brought to an end. End of quotation. In light of the foregoing, you can say that the consequences of Israeli breaches for third state are as follows. First, states have to cooperate in all lawful means to make sure that Israel withdraws from OPT, stops its policy of expansion of settlements and dismantles extant settlements, and recognises the right of the Palestinian people to self-determination. Secondly, states must not recognise the fait accompli situation that Israel's created in OPT. Above all, regarding the change of status and demographic situation of the city of Jerusalem. So, the Israeli occupation of Palestinian territory is illegal and has to stop unconditionally and immediately. Consequently, third states and international organisation must support without delay all efforts aimed at putting an immediate and conditional end to this occupation, and to abstain from all action or admission which might contribute to this illegal situation being maintained. Speaking about international organisation, and given that the Court is called upon to answer the questions addressed by the General Assembly of the United Nations, that organisation has a particular responsibility. The organisation of the United Nations, and specifically the General Assembly and Security Council, must take all necessary measures to ensure the implementation of their relevant resolutions without delay, and examine additional measures necessary to put an end to all or remove all obstacles to the realisation in the way of the Palestinian people to its right to self-determination, put an end to the prolonged occupation, colonisation and annexation of Palestinian territory by Israel, intermediate measures aimed at changing the demographic composition and the character of the holy city of Jerusalem. Distinguished members of the Court, Lebanon requests the court to find that you have jurisdiction to respond to the request for advisory opinion contained in 77247 and to do this in the light of our written and oral comments.
Ladies and gentlemen, members of the court, the late Pope John Paul II once said, if you want peace, want justice, defend life. If you want life, embrace the truth. As the highest judicial authority in our globalized world, Lebanon urges you to help in giving justice to the Palestinian people so we can have peace in the Middle East. Thank you.
Je remercie la délégation du
I thank the delegation of Lebanon for its statement.
participating delegation in Libya to make its oral statement before the court. I thus call upon Professor Ahmad Al-Gihani to take the floor.
Je remercie la délégation du Koweït. Mr. President, distinguished judges, Monsieur le Président, c'est un honneur pour moi de représenter ma délégation devant votre cour. Tout d'abord, permettez-moi de dire que les souffrances du peuple palestinien, et plus particulièrement celles aujourd'hui de la bande de Gaza, sont la preuve criante des conséquences de l'incapacité de saisir la cause. Scale and systematic heinous crimes being committed by the occupying power force, depriving the civilian population of food, water, and essential supplies. The aggression of the power of occupying power has not spared children, women, elderly people. There is no safe place for the people in Gaza to go to. The crimes amounted by Israel, the crime committed by Israel tantamount to the crime of genocide and other international crimes stated in the Article 5 and 6 and 7, 8 for the Rome Statute. This call on the international community as a whole and on organs of the United Nations to put an end to this tragedy and take concrete steps in order to enable the Palestinian people to realize their legitimate rights of self-determination. Therefore, we believe guidance from the court as the highest judicial organs in the United Nations, and it is necessary and important. The presentation of the state of Libya before your court will address the following points. First, the jurisdiction of the court, then the illegality of the occupation of the Palestinian territory, then the consequences of the Israeli illegal actions, and then the summit. We can start from the first point, that the jurisdiction of the court, as you know, Mr. President, member of the court, that the Article 96, paragraph 1 of the United Nations Charter provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. On the other side, the Article 65, paragraph 1 of the court's statute further stipulates that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such request. These two provisions are, according to our view, sufficient to establish the competence of the General Assembly to request the advisory opinion from the court and the jurisdiction of the court to give the requested opinion. We go to the second point, the applicable law. The international humanitarian law. First, the international humanitarian law It is, as you know, settled that 1949 Geneva Convention relative to the protection of civilian persons in times of war apply to the OPT, as noted by the court in the Wall opinion. In addition of that, the 1907 Hague Regulation have become a part of customary law and therefore apply to the OPT, despite the Israeli argument that the Fourth Geneva Convention does not apply to the OPT. The court found, as a matter of treaty law, that does indeed apply, as it would to say, and occupied territory to prevent an armed conflict arising between two or more high contracting parts. In 2001, the Conference of High Contracting Parties reaffirmed the applicability of the Fourth Geneva Convention in the Occupied Palestinian Territory, including East Jerusalem, Quds, and called inter alia upon the occupying power to immediately refrain from committing grave breaches involving any of the acts and mentioned in the Article 147 of the Fourth Geneva Convention, such as killing, torture, deportation, depriving of the rights of fair and regular justice and trial, extensive destruction and appropriation of the property not justified by military necessity. Plus that is applied the international human rights law. A variety of international human rights treaties apply to the proceedings. Among the most important of these are the International Covenant of Civil and Public Rights, International Covenant on Economic, Social and Cultural Rights, the International Convention on Elimination of All Forms of Racial and Discrimination, the International Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention on All Rights of the Child, and the Convention Against the Torture and other forms of cruel, human, degrading treatment and punishment. Both states, Palestine and the occupying force, are parties to these treaties. Established norms of general international law applicable to the proceedings. As stated by the International Law Commission, norms of general international law, jus cogens, embody three essential characters. One, they protect the value of fundamental to the international legal order shared by the international community as a whole. The second, they are universally applicable by virtue of their non-derogability, since states cannot derogate from them by creating their own special rules that conflict with them. They are superior on other norms of international law, entailing obligation of an erga omnes character. The court itself has recognized the erga omnes character of such obligation. These are the norms. First, the inadmissibility of the territorial acquisition by threat or by use of the force. The prohibition against the threat or use of the force against the territorial integrity or political independence of another state is enshrined in the Article 2, Paragraph 4 of the United Nations Charter and is an essential cornerstone of the international legal order. The article, I quote, the Article 2.4 provides that all members shall refrain in their international relation from the threat or use of force against the international integrity or political independence of any state, or in any other manner in consist with the purpose of the United Nations. In case of the armed activity on the territory of the Congo, the court has stated that the prohibition of the use of force is a cornerstone of the United Nations Charter. Then we go to the second paragraph, which is the prohibition against racial discrimination and apartheid. The prohibition of racial discrimination and apartheid is reflected most in third, as the court has very recently underlined that that 182 states are parties in the third, a fact which confirms that universal character of the convention. Those parties include both of state of Palestine and the occupying force. It is well established that the prohibition of the racial discrimination forms part of customary law and has long been recognized as premonitory norm. The court in Barcelona Traction considered the prohibition of the racial discrimination to be a norm of erga omnes character, stating that such obligations derive from, example, contemporary international law, from the outlawing of acts, aggression, and genocide, as also from the principle and rules of concerning the basic rights of the human person, including protection from slavery and racial discrimination. Third, the obligation to respect the right of the self-determination. The right of self-determination exists in customary international law and recognized by the United Nations Charter, as well as in the ICCPR and ICESCR. It must be also stated that the obligation to respect the people's right of self-determination is a premonitory principle of the general international law. As the court noted in the East Timor case, that right in self-determination is one of the essential principles of contemporary international law, enjoying an erga omnes character. The United Nations General Assembly has repeatedly confirmed the right of Palestinian people to self-determination. For example, the resolution 2672 of the 8th December 1970. It recognized that the people of Palestine are entitled to equal rights and to self-determination in accordance with the Charter of the United Nations, and that full respect for the inalienable rights of the people of Palestine is an indispensable element on the establishment of a just and lasting peace in the Middle East. Mr. President, members of the court, now we come to the illegality of the Israeli occupation of the Palestinian territory. The Israeli 6 decades occupation of Palestinian territory is a continuing gross and systematic breach of its legal obligation under the United Nations Charter and the general international law, also international humanitarian law, international human rights law, and customary international law, including the violation of at least 3 premonitory norms of general international law, of jus cogens and erga omnes charter. It shows that Israel has annexed and plans to continue to annex Jerusalem, Al-Quds, and the rest of the West Bank, that has composed systematic and comprehensive racial discrimination tantamount to apartheid against the Palestinian people, based on their race, and that it has denied their right to self-determination in their own land. In view of these policies and practices, Israel's occupation of the OPT is unlawful, rendering Israel's continued presence in the OPT and internationally wrongful act as seriously breaches the last 3 premonitory norms of the general international law. Derogation from which is not permitted committed. Israel's occupation of the Palestinian territory seriously breaches premonitory norms of the general international law, and the occupation of the OBT seriously breaches the at least three premonitory norms of general international law, derogation from which is not permitted. On the matter of self-determination, the occupying power has not only denied, Israel has not only denied the right of the Palestinian people to self-determination, but actively tried to suppress and to extinguish it even after the court's ruling in 2004. That Israel has under obligation, ergo omnes, to respect the right of the Palestinian people to self-determination. Israel has, in fact, escalated the policies and practices with the specific intention of permanently precluding the exercise of the right of Palestinian people, including their right to independence and in their state. It is very apparent and evident that the General Assembly considered the Israeli military occupation as illegal, and Security Council the overriding necessity to the prolonged occupation when the occupation was in its early years. There is no doubt that it is unlawful, is even more apparent of the flagrant now that has come to the 6 decades. As consequences of Israeli prolonged 6-decade occupation of the OPT is a clear violation of premonitory norms of the general international law, derogation from which is not permitted. The occupation itself must be regarded as illegal with all relevant legal consequences that attach under the law and international responsibility. This means that it must brought to an immediate and unconditional end and total end. Mr. President, distinguished justice, what we mentioned is also means that the Palestinian people has the right to resist the occupation by all means, and it is a moral and legal obligation upon all states to assist and support the Palestinians in their legitimate struggle for liberty and independence. Now, Mr. President, members of the court, come to the consequences. We start by legal consequences on the occupying power. It must fulfill the occupying power, or Israel must fulfill its obligation to respect the Palestinian people's right to self-determination. Israel must immediately end the violation of the international obligation to respect the right of the Palestinian people to self-determination by ceasing all acts and measures that prevent and impede the Palestinian people from exercising their right to self-determination, including the immediate cessation of the occupation in all its manifestations. The obligation of the state responsible for an act contrary to the international law in general and international law. Accordingly, Israel is obligated to immediately cease of violation of the legal obligation in Jerusalem and the occupied Palestinian territories as a whole. The cessation of this violation includes, inter alia, the dismantling of the illegal structure, including the settlements and the wall. Israel shall be obligated to make restitution and compensation for the damage suffered by the Palestinian people, and Israel obligated to immediately repeal all these laws that aims to racial segregation and discrimination enshrining in the apartheid regime imposed against the Palestinian people. The other consequences, the legal consequences for the third parties or for the third states. Given the orga omnis nature of the right to self-determination in accordance with the standing resolution of the United Nations General Assembly, it is also incumbent on all states to ensure that any impediment to the exercise of the right of self-determination by the Palestinian people is brought to an immediate end. In view of the nature and importance of the rights and obligations involved, all states have an obligation not to recognize the illegal situation resulting from Israeli violation in the occupied Palestinian territories, including Jerusalem. They are also obliged not to provide aid or assistance in maintaining the situation created by these illegal acts. Furthermore, the states parties to the Fourth Geneva Convention are obliged to ensure that Israel complies with the international humanitarian law as enshrined in that convention, including the forcible transfer of Palestinians and the transfer of Israeli citizens in the occupied Palestinian territory. Also, there is a legal consequences on the UN and all the United Nations. The United Nations, and in particular General Assembly and the Security Council, should consider what further measures are necessary to remove without delay any obstacle of the realization of the Palestinian people's right to self-determination, and to take necessary measures to ensure the implementation of its relevant resolution without further delay. Then also the United Nations should consider that further action is required to bring illegal occupation, ensure the implementation of the relevant resolution without further delay. Mr. President, distinguished judges, lately we have the Libyan state submission. I will, with your permission, I will give the floor to my colleague, Dr. Nasser Al-Ghita.
I thank Professor Al-Kihani, and I'll give the floor to Mr. Nasser Al-Ghita. You have the floor, sir.
Mr. President, members of the court, it is my honor to appear before you today on behalf of the state of Libya. And with your permission, I will proceed to the final points of our presentation today, which is the submissions to the court. We submit to the court that the court has jurisdiction to deliver the advisory opinion requested by the General Assembly, as there are no grounds for declining to exercise its jurisdiction. We believe that Israel is responsible for serious breaches of obligations arising under peremptory norms of international law, including but not limited to the illegality of the admissibility of the acquisition of territories through the use of force, and the prohibition of aggression, the prohibition against racial discrimination, and apartheid, and the right of the Palestinian people to self-determination. The occupying power is obliged to immediately, unconditionally, and completely end its occupation and withdraw from the OPT. This entails, inter alia, revoking all legislation and measures aimed at the annexation of Jerusalem and the rest of the OPT, end of aggression, and the blockade on Gaza, withdrawal of all occupation forces, and dismantling of its illegal settlements and their associated regimes, to revoke all of its discriminatory legislations, measures against the Palestinian people, and to respect the unalienable rights of Palestinian people to self-determination and the Palestinian refugees to return to their home, to provide assurance and guarantees of non-repetition of the above-mentioned violations, to make full reparation for injuries caused by the policies and practices vis-à-vis the state of Palestine and the people of Palestine as a result of the internationally wrongful act or actions. All states and international organizations, including the United Nations, are obliged not to recognize the illegal situations resulting from the international wrongful act of the occupying power, not to contribute to the violations of the right of the Palestinian people, and by not rendering aid or assistance in any way to the occupying power, to cooperate to protect the right of Palestinian people and to end the occupying power's violations of those rights, by enabling the Palestinian people to exercise their right to self-determination, and by holding accountable those responsible for crimes related to the colonization of the West Bank, including East Jerusalem, the unlawful annexation of the OBT, and the blockade and the current aggression on Gaza. And more generally, the violations of the fundamental rights of the Palestinian people as a whole, including the right to self-determination and to be free from racial discrimination and apartheid, as well as the right of Palestinian people to life and liberty. I would like also to stress that our observation before the court today has no legal effect in relation to the recognition of Israel. Mr. President, members of the court, this brings our presentation today to the end, and I thank you and your member of the court for your kind attention. Thank you.
I thank the delegation of Libya for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv.
Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today. Discover the Islam Channel podcast, where you'll find a perfect blend of inspiration, news, and business insights, all rooted in the beauty of our deen. Stay up to date with the latest trends. Engage in thought-provoking discussions. Subscribe to the Islam Channel podcast today.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that.
Please be seated. The sitting is resumed. I
now invite the delegation of the next state, Luxembourg, to take the floor. And I give the floor to Monsieur Alain Germaud. You have the floor, sir.
Mr. President, members of the court, it's an honor for me to present before you today, as agent of the government of Luxembourg, the oral observations in this request for an advisory opinion. Luxembourg has the greatest respect for the court and the international justice system in which it exercises its function. The participation of Luxembourg in this request demonstrates its resolve to strengthening an international rules-based order for which the court has an essential role. Luxembourg voted in favour of Resolution 77247 of the General Assembly and hopes that the advisory opinion of the court will strengthen the role of the UN and contribute to achieving a peaceful solution of the Israeli-Palestinian conflict consistent with international law. My country fully supports the vision set out by the Security Council of a region in which two democratic states, Israel and Palestine, live side by side in peace within safe and recognized borders. As a member state of the European Union, Luxembourg supports the agreed position of the Union on the Middle East peace process as set out in the Council conclusions as well as the declarations by the Union. As regards the admissibility of the request, Luxembourg refers to its written submission of 20th July 23. It believes the court has jurisdiction to respond to the request, and there are no compelling reasons justifying a refusal by the court to issue an advisory opinion. Its discretionary power under Article 65 of the Statute of the Court. As to the substance, of the request, Luxembourg has 4 observations on the legal points in the questions put to your court. To wit, applicable law, the Palestinian people's right to self-determination, occupation, colonization, and annexation of Palestinian territories, as well as the legal consequences arising therefrom from Israel and other states. Firstly, applicable law. Your court had already made a determination in its opinion 9 July 2004 on the legal consequences, construction of a wall in the OPT. I'd recall here the applicable law items as part of this request. The principles set out in the UN Charter in respect to the use of force, reflecting customary international law as corollary, unlawfulness in any acquisition of territory resulting from the threat or use of force, the principle of the right of peoples to self-determination as enshrined in the Charter, Resolution 2625 of the General Assembly and the 266 Human Rights Covenants, rules and principles of international humanitarian laws arising from the provisions of the Hague Regulations 1907, customary value, and the Fourth Genevan Convention and international human rights law remain relevant. Specific resolutions of the Security Council pertaining to the OPT and the rights of the Palestinian people, that of the General Assembly as they reflect international customary laws, the Declaration of Principles on Self-Government Interim Arrangements of 13 September 1993, and lastly, the Israeli-Palestinian Interim Agreement on the West Bank Gaza Strip, 28 September 1995, known Oslo Accord 2. To that are added, since 2012, multilateral legal instruments to which Palestine's become a party and through their object form part of the framework of this analysis. My second observation concerns the right to self-determination. This right is explicitly set out in Articles 1 and 55 of the Charter. Under Article 1, Paragraph 2 of the Charter, one of the aims of the UN is to develop between nations amicable relations based on respect for the principle of equality of the rights of people and their right to self-government, take all other measures appropriate to strengthening world peace. More specifically, the right to self-determination was regularly recognized by various UN bodies. It was set out in Resolution 2625 of the UNGA, stating that every state has the duty to promote the fulfillment of the right of peoples to self-government in accordance with Charter provisions. The UNSC also stressed the need for a fair and lasting settlement of the Israeli-Palestinian conflict, taking account, and I quote, of the legitimate political rights of the Palestinian people. Your court set out in the Advisory Opinion 2004 that the existence of a Palestinian people is not at issue, indicating the right to self-determination is amongst the legitimate rights of the Palestinian people mentioned in the Oslo II Agreement, confirming that this right constitutes an erga omnes obligation. In the opinion on the legal effects of the separation of the Chagos archipelago of Mauritius, your court recognized the right to self-determination is a fundamental human right with the character of a customary norm. It further set out that the right to self-determination must be the expression of the free and genuine expression of the people concerned, even which, if under international customary law, it doesn't impose a particular mechanism for its implementation in all cases. As regards the OPT, the development of settlements and resulting fragmentations gravely undermine the right to self-determination of the Palestinian people and thereby impede the building of a viable Palestinian state whose prospect recedes with the continuing infringements of the integrity of the Palestinian territory. In conjunction with the Palestinian people's right to self-determination, The UNGA and the Security Council affirmed the unlawfulness of Israeli settlements and required that Israel put an end to these activities of settlement that all have serious and prejudicial consequences inter alia for the human rights of the Palestinian people, notably its right to self-determination. Under the law of international responsibility, the violation of this right constitutes an international wrongful act of a continuing character. Under Articles on State Responsibility for International Wrongful Acts adopted by the International Law Commission in 2001, the state responsible maintains the duty to discharge the violated obligation if it's still in force, which is plainly the case here. Also duty-bound to put an end to the international wrongful act. This duty required all the more that the fulfillment of the right to self-determination is a key condition to the guarantee effective right of human rights, as well as the preservation and promotion of said rights. I'll now turn to my third observation concerning occupation, colonization, and annexation of Palestinian territories. Occupation is an objective de facto situation characterized by the effective control exercised by a state on a given territory. The legal regime of occupation applies independently from the lawfulness of the operation that allowed the state to exercise its effective control in the occupied territory. Many UNSC resolutions use expressions occupied territory or occupied Palestinian territory, starting with Resolution 242 of 67. The Court and the Assembly recalled to Israel the obligations by calling upon it as occupying power to discharge its legal obligations and the upon it under the Fourth Geneva Convention applicable to all occupied territories by Israel since 1967.
Les règles du droit de l'occupation reposent sur
The rules of occupation rest the idea that occupation is but a temporary situation and based on the principle that the fact that occupying power doesn't acquire sovereignty over the territory and must refrain from taking measures that could lead to permanent changes, in particular social, demographic and economic.
et l'ordre public dans le territoire occupé.
Security and public order, so in short, the well-being of people being protected. This has not been done. The statute of military occupation and the principle of the protection of the population subject to that, the applicability of international law, of international humanitarian law and international human rights law have also been confirmed a number of times. It has been established that the scope of the application of international humanitarian law does not depend on the territorial extent of a state, but about effective control. International laws and human rights applicable to all of occupied Palestinian territory and occupying power exercised by Israel is to protect the population in occupied territories. This reinforces the rights of the people under occupation in terms of humanitarian law. Israel, of course, has the right to protect itself and its people, but all measures taken in this nonetheless have to comply with the relative rules of international law. As a consequence of that, Israel, as an occupying non-sovereign power on Palestinian territory, has to ensure that throughout its occupation, that its occupation is compliant with international humanitarian law and human rights law. The court noted in 2004 that Israel had violated a number of human rights obligations for the Palestinians. These violations seem to have continued because of the expansion, the rapid expansion of settlements and the associated infrastructure. In its practice of establishing, extending colonies, Israel undertook the transfer of a part of its own civilian population towards Occupied Palestinian Territory, violating Article 49, Paragraph 6 of the Fourth Geneva Convention. This took place despite the express and repeated condemnations of this practice and the appeals to stop it, but by the Security Council and the General Assembly, and this notwithstanding the confirmation of your court of the unlawfulness of this practice in your opinion of 2004. The court also found that in this opinion Israel had destroyed and appropriated Palestinian properties in a manner unjustifiable by military necessity within the framework of armed conflict, and that this was a violation of Articles 46 and 52 of the Hague Regulations and Article 53 of the Fourth Geneva Convention. Now, recent reports of the UN Secretary-General and of the High Commissioner for Human Rights of the United Nations show that Israel continued to destroy and appropriate unlawfully properties across the Palestinian territory which it occupied, as it encourages and facilitates the expansion of its settlements. These reports show equally that Palestinians are increasingly victims of violence carried out by Israeli settlers, and they do not enjoy adequate protection against violence on the part of Israeli security forces. The Secretary-General, and the High Commissioner both concluded that Israel thus did not protect the Palestinian population in conformity with the obligations upon it under Article 43 of the Hague Regulations, Article 27 of the Fourth Geneva Convention. They pointed out that this violence, accompanied by appropriation and destruction of Palestinian property, in certain cases constrained Palestinians to leave their homes, which sounds like forced transfer and violation of Article 49, Paragraph 1 of the Fourth Geneva Convention. The measures taken by Israel in OPT entail fundamental changes inter alia demographic which may take on a permanent character. They negatively affect the Palestinian population instead of being beneficial to it, and contribute to the creation of a coercive environment. So, in other words, they run counter to the principles of the right or the occupation law. Now, I'd like to talk about colonisation and annexation. The international community shares growing concern regarding the colonisation activities of Israel in occupied Palestinian territory, which constitute a practice which is prejudicial to the achieving of a two-state solution. Your court concluded in the opinion of 2004 that the settlements installed by Israel on OPT were done so in breach of international law. The Security Council denounced this situation on numerous occasions, and in its resolution 2334, the Council reasserted its determination that the establishment of settlements constitute a threat for international peace and security. It was a flagrant violation of international law and a major impediment to the realization of a two-state solution and a just and lasting and comprehensive peace, and reiterated its demand that Israel cease immediately and completely all activity of settlement. The settlement activities cannot be justified by other aims either. If Israel is confronted by an armed attack, well, it has the right to exercise its right to self-defense. But its activities of colonization cannot be justified under self-defense. They would not constitute in any event a necessary or proportionate measure, as international law requires for all measures taken in the exercise of the right to self-defense. The wrongfulness of this activity cannot be precluded by necessity under customary international law, as reflected in Article 25 of the Articles of the ILC of 2001. inter alia because it's clearly not the only means for Israel to safeguard essential interest against a grave and imminent peril. This finding of wrongfulness remains all the more founded given that since 2004 Israel has pursued and increased its policy of settling colonies on OPT, contrary to its obligations under international law. As your court pointed out, within the framework of the construction of a wall, such a situation can lead to a fait accompli and to a de facto annexation process. Now, one of the fundamental principles of international law is the prohibition of this type of annexation. As you can see in Resolution 2625 of the General Assembly, no territorial acquisition obtained by the threat or the use of force can be recognized as legal. The development of settlements thus compromises the viability of a future Palestinian state, and thus the perspective of achieving a negotiated two-state solution. Mr. President, if you'll allow me, I'll come now to my fourth and last observation. Let me look first of all at the legal consequences arising for Israel, and then I'll look at those which arise for other states. For Israel, well, your court was of the opinion, in your opinion of 2004, that Israel had to put an end to the violation of its legal obligations, including obligations under international humanitarian law and its obligation to respect the right of the Palestinian people to self-determination, to repair damage caused by these violations. The examination of the current situation shows that these violations continue, and Israel must cease this. They relate to the right of peoples to self-determination, whose customary character is well established, and rules currently in force in international humanitarian law and international human rights law applicable to the situation in OPT. The first legal consequence resulting from the responsibility is clearly to cease the illegal act, according to the terms of Article 30, Sub A of the Articles of the ILC of 2001. The responsible state, the state responsible for an unlawful act, has the obligation to bring it to an end if it is continuing, and the two conditions are, firstly, the continuing character of the unlawful act, and secondly, the fact that the rule breached remains in force. Thus, within the framework of the incident proceedings, the obligation of cessation implies that the policy and practices identified as breaching international law, and in particular settlement activities, should cease, and that domestic law legal acts on which they are based need to be rescinded. Let me recall paragraph 4, Resolution 2334 of the Security Council, which underlines, I quote, "It's essential that Israel puts to an end its settlement activities to preserve the two-state solution, and demands the immediate adoption of energetic measures to reverse the negative tendencies on the ground which put in peril the two-state solution." Regarding the breaches of international humanitarian law and of the international law of human rights committed on occupied Palestinian territory, it's also important to point out that Israel must investigate and reveal the facts on the ground and conduct inquiries to prosecute and identify and prosecute the people responsible. Now, regarding other states and their responsibilities, well, we should recall that all high contracting parties to the Geneva Conventions have the obligation to comply with and ensure compliance with international humanitarian law. Also, in the opinion of 2004, your court was of the opinion that Israel had breached its obligation to respect the right of the Palestinian people to self-determination and to some of its obligations under international humanitarian law. The court concluded that all states have the obligation to not recognize an unlawful situation, and that they have the obligation to respect human rights and respect the right to self-determination. So, from this, an obligation results, namely for states to not recognise the legitimacy of a situation which is contrary to international law, either formally or by acts which would imply such recognition. No form of annexation, including partial, could be recognised under international law. The General Assembly and the Security Council have both called for non-recognition of those situations created by annexation or the denial of the right to self-determination. States must cooperate to bring to an end all these violations, if necessary, collectively. That includes the role of the Security Council and the General Assembly of the UN, where needs be also other international organisations such as the European Union. Finally, respecting the international status of occupied Palestinian territories entails other effects on the economic level. Let me recall that in Resolution 2334, the Security Council requested all states to make a distinction in their exchanges between the territory of the State of Israel and occupied territories, and this since 1967. This translates in European law, EU law, by taking into account international law and the opinion of your court of 2004, differentiating products according to their origin. Mr. President, if you'll allow me, I will just move to some conclusive remarks. The court requested in 2004 the UN organization as a whole to redouble its efforts to rapidly bring an end to the Israeli-Palestinian conflict in order to establish a just and lasting peace in the region. This demand is more relevant than ever. It echoes the obligation on Israel and on Palestine under the UN Charter and international law, customary international law, to peacefully resolve their disputes by taking up peace negotiations and implementing the relevant resolutions of the UN. Israel has legitimate security concerns and thus enjoys a broad discretion in the choice and implementation of the measures required. However, its acts under self-defense or national security must comply with international law, inter alia, international humanitarian law and human rights law. This is essential to improve the humanitarian condition of the persons under occupation and to realize a just and lasting peace. Mr. President, distinguished members of the Court, this brings my intervention to a close, and I'd like to thank you for your kind attention.
I thank the delegation of Luxembourg for its presentation.
Right now, the next participating delegation, Malaysia, to address the Court and call upon His Excellency, Mr. Dato Seri Utama Haji Muhammad Haji Hassan, to take the floor.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the Court, it is a great honor and privilege for me to represent Malaysia in this advisory proceeding concerning the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. As I stand here today, Gaza is facing devastation, including in Rafah at the southern end of the Strip. The West Bank is also at risk. Safeguarding Palestinians from destruction is crucial, especially in light of Israel's non-compliance with the recent order of the provisional measures of this court on 26 January 2024 in the case brought by South Africa. The matter before you today is of grave concern to the General Assembly, all states, and the Palestinian people. The Palestinian people have long suffered dehumanization, demonization, brutal collective punishment. They have endured and are still enduring the denial of their right to self-determination due to the policies and practices of Israel in the OPT. It is incumbent upon each of us to do our part in ending their decades of long suffering and to work towards peace in their land. Malaysia has consistently supported peace for the Palestinian people, aligning itself with relevant General Assembly and Security Council resolutions, as was the case in the advisory opinion on the wall. This court is uniquely positioned to give authoritative guidance on the legal questions submitted by the General Assembly. With a firm belief in this court's role as the custodian of the international law, we remain confident that justice and peace will prevail for Palestinians. Malaysia's submission today is straightforward. The policies and practices of Israel in the OPT are a set of acts and measures that individually breach a number of rules of public international law. These policies and practices, however, taken together, also amount to serious breach of right to self-determination of the Palestinian people, which is protected by peremptory norm of international law. The occupation of Palestine for its part is nothing but these policies and practices itself. The occupation itself is thus in serious breach of peremptory norm of international law and must be brought to an end immediately. In my presentation, I will first deal briefly with the court jurisdiction and its discretion to respond to the request of the General Assembly. The second part of my presentation summarizes Malaysia's position on the legality of the policies and practices of Israel in the OPT. In the third and final part, I will set out the legal consequences that arise for Israel, for all other states, and for the United Nations, respectively, from what Malaysia submit as a flagrant denial of Palestinian people's right to self-determination. Mr. President, members of the court, as regard the court's jurisdiction to render this advisory opinion, Malaysia considers that the requirement of Article 65, paragraph 1 of the Statute of the Court, read together with Article 96, paragraph 1 of the Charter of the United Nations, are plainly satisfied in the present case. First, the General Assembly is competent to request an advisory opinion, given that the United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in satisfactory manner in accordance with international legitimacy. Second, the question addressed to the court are legal questions framed in terms of law and raising problems of international law. The request that the court determine the existence of violence of international law and their corresponding legal consequences is by its very nature susceptible to a reply based on law. Malaysia further submits that there are no compelling reasons preventing the court from exercising its jurisdiction, which after all represent the court's own words, its participation in the activities of the United Nations, which in principle should not be refused. Israel and others have argued that the court is being asked to resolve what is essentially a bilateral dispute between Israel and Palestine and to make permanent status determinations. Israel, in its unsurprisingly brief written statement, argues that both interested parties have given their express and binding consent to resolve all relevant disputes through another settlement means, namely through direct dialogue. Malaysia stresses first and in principle that questions of self-determination are never purely bilateral matters between states. They refer to a peremptory norms of international law, which produces erga omnes obligations owed to the international community as a whole. That being so, all states and the United Nations have a legal interest in the protection of the rights involved. But quite apart from that, the questions before the court are not at all concerned with settling disputes between Israel and Palestine. The court is requested to set out the legal consequences of Israel's policy and practices in the OPT. Its advisory opinion will inform the exercise by General Assembly of the permanent responsibility of the United Nations towards question of Palestine. Such matters neither involve the determination of permanent status issue, nor are they for the parties to any direct dialogue to waive or disregard. As a final point, Malaysia recalls that it was on this ground that the court decided to exercise its advisory jurisdiction in the world, rejecting these and other arguments which have been replayed in this proceeding, such as the court does not have sufficient information and evidence. Malaysia admits that the court was correct then, and that there are no more compelling reasons today for the court to refuse to render the opinion requested than there were 20 years ago. Mr. President, members of the court, the objective of Malaysia in making these oral submissions is not only to make its position known on the legal question before the court. Its objective is also to assist the court in its important work. With that in mind, Malaysia offers here a way of thinking about the substance of the request of the General Assembly. The General Assembly, Mr. President, refers its request to the right to the self-determination in particular, in question A, to the prolonged occupation, settlement, and annexation of the Occupied Palestinian Territory, to the measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem, and to the adoption of discriminatory legislation and measures. And in question B, then, the Assembly refers to the policies and practices of Israel referred to in question A and asks the court how this affects the legal status on the occupation and what the corresponding legal consequences are. Malaysia submits that the policies and practices of Israel in the OPT consist of a set of an acts and of legislative, administrative, and other measures. These include the construction, maintenance, and extension of a wall in the OPT, the establishment, maintenance, expansion, and protection of settlement in the OPT, along with the associated discriminatory legal regime, the demolition of Palestinian homes, and the forced transfer of the Palestinians in that territory, the control and the provision of food, water, electricity, and other amenities to the OPT, and other acts and measures, detailed both by United Nations organs and by the states having chosen to appear before you. All these policies and practices constitute in and of themselves violation of individual rules of international law, including international humanitarian law and the law of occupation, international human rights law, the prohibition of the use of force, and the associated prohibition of acquisition of territory by the threat or use of force, and others. All of this is detailed in Malaysia's written statement, as well as in other written statements submitted to the court in these proceedings. And we have heard over the last few days many states argue before the court along these lines. Malaysia submits that, taken together, these policies and practices, apart from breaching individual rules of international law, also constitute a serious breach of the Palestinian people's right to self-determination, a jus cogens obligation incumbent on all states and owed to the international community as a whole. Malaysia further submits that these policies and practices and in end of themselves constitute the occupation of the Palestinian territory. These policies and practices, Mr. President, is nothing but the means by which Israel is exercising its control over the OPT, the means by which it is enforcing its occupations. These policies and practices resulting as they do in a serious breach of the Jewish Kogan's right to self-determination cannot but affect the legal status of the occupation of the Palestinian territory by Israel, rendering it unlawful. Mr. President, allow me now to put some flesh on the bones of the argument that I have just presented. First, there can be no doubt that the right to self-determination is a peremptory norm of international law, from which flow obligation erga omnes. This court has already confirmed as much on numerous occasions. It has done so both explicitly with respect to the erga omnes character of the relevant obligations and by drawing the consequences of a serious breach of the right to self-determination in a manner that reflects the special consequences that accrue to a serious breach of peremptory norms of international law. Second, there can also be no doubt that the right to self-determination applies to the Palestinian people. As this court noted in the World Advisory Opinion, as regards to the principle of the right of people to self-determination, the existence of Palestinian peoples is no longer an issue. Third, Malaysia submits that there are 4 core substantive elements of the right to self-determination. The first such element is the right of a people to territorial integrity. As this court confirmed in HAGUE, the right to territorial integrity of a non-self-governing territory is a corollary of the right to self-determination. The second element is the right of the people to territorial unity and the protection of its integrity as a people. As this court found in the World Advisory Opinion, alterations of the demographic composition of the occupied Palestinian territory constitute a violation of the right to self-determination. Third, the people has a right to permanent sovereignty over its natural wealth and resources as part of its right to self-determination. The General Assembly has described such permanent sovereignty as a basic constituent of the right to self-determination and has further declared that a violation of the rights of people to sovereignty over their natural wealth and resources is contrary to the spirit and principle of the United Nations Charter. Finally, the fourth element of the right to self-determination is the freedom of people to pursue their economic, social, and cultural development. According to the General Assembly, this is a fundamental aspect of the principle of equal rights and self-determination of peoples as enshrined in the United Nations Charter. The fourth submission that Malaysia wishes to make is that the policies and practices of Israel in the OPT violate numerous individual rules of international law, as well as each one of the 4 core substantive elements of right to self-determination. I will demonstrate this as briefly as possible, Mr. President. Israel's policies and practices with respect to the legal status of East Jerusalem, along with its establishment, facilitation, and expansion of settlements in the OPT with their associated infrastructure and discriminatory legal regime amount to attempts to de jure and de facto annexation respectively. This is in clear breach of provision of acquisition of territory by the threat or use of force are corollary of the provision of the use of force in the United Nations Charter, which is a peremptory norms of international law. Israel's transfer of civilians into the OPT is a breach of Article 49, paragraph 6 of the Fourth Geneva Convention in 1949 and constitutes a war crime per the Rome Statute in the International Criminal Court. Apart from constituting individual breaches of international law, these policies and practices violate the territorial integrity of the Palestinian people and thus the right to self-determination. Israel policies and practices which aim at changing the demographic composition of the OPT, along with the creation of enclaves of Palestinians, the demolition of their homes, the limitation of their freedom of movement, including the blockade, seize and perpetual evacuation of the Gaza Strip, constitute violations of international humanitarian law and the international human rights law. But they also violate the unity and integrity of the Palestinian people and thus its right to self-determination. Israel policies and practices of expropriation of Palestinian land for use as settlements, of control over all water resources in the West Bank, and control of water provision in the Gaza Strip, of granting licenses for oil and gas extraction, and of operating quarries in the OPT constitute violations of international humanitarian law and of international human rights law. But they also violate the permanent sovereignty of the Palestinian people over its natural wealth and resources. They thus violate its right to self-determination. Israel's policies and practices of exploitation of natural resources, of restrictive zoning and planning regime in the OPT, of blockading Gaza and subsequently razing it to the ground, of hampering, of limiting access of Palestinians to health services, educational establishments, and primary sources of water, of preventing Palestinians from accessing sites of religious and cultural importance in the OPT, of restricting their freedom of association and expression, and of condoning settler violence, constitute violence of international law and the international human rights law. But they also violate the Palestinian people's freedom to pursue the economic, social, and cultural development, and thus its right to self-determination. Mr. President, 20 years ago, exactly 20 years ago, almost to the day, Malaysia argued before this court the Israel construction of a wall deep inside the OPT violated the Palestinian people's right to self-determination. And this court found in its advisory opinion that construction, along with measures taken previously, severely impedes the exercise by the Palestinian people of its right to self-determination, and it is therefore a breach of Israel's obligation to respect that right. Along with these measures taken previously, the court said, that was a reference, as is evident from the preceding paragraph of the advisory opinion, to the policies and practice of Israel involving the establishment of settlements and their associated regime. If that was the case then, 20 years ago, a theory that this must be now case, a theory that must be the case now, how could it not be? If anything, Israel has maintained and extended the wall, and it has escalated the measures taken previously and ramping up the establishment of the settlement, expanding them, providing funding and amenities to them, as well as security, and extending the associated discriminatory legal regime. It has also continued and escalated the demolition of Palestinian homes, the practice of forced transfers, and the transfers of its own civilian into the OPT. Even in 2004, based on conduct less grievous than the one before the court today, Israel's breach of the right to self-determination of the Palestinian people was found to constitute a serious breach of a peremptory norm of international law. Reading the relevant paragraphs of the court's opinion leaves no room for doubt in this respect. The court called upon all states not to recognize the illegal situation resulting from the construction of the wall in the OPT and not to render aid or assistance in maintaining the situation created by such construction. The court also found that it is for all states to see to it and that any impediment resulting from the construction of the wall, the exercise by Palestinian people of its right to self-determination is brought to an end. This language closely reflects the Article 41 of the Articles of State Responsibility regarding the particular consequences of serious breaches of obligations under peremptory norm of international law. The effectory argument I made with respect to the existence of violation of the right to self-determination applies here as well. This is not just any violation, Mr. President. It is a serious breach of peremptory norm of international law. It is, if it were so, with respect to the much more limited issue before the court in 2004, it must be certainly to be today. We are no longer talking about the construction of wall. We are talking about the whole host of policies and practices of the acts and measures so well documented by the United Nations and by most of the states that have spoken in these proceedings. This could not amount to anything less than what the construction of a wall amounted to 20 years ago. Indeed, they underscore the devastating deterioration of situation in the occupied Palestinian territory since then. Mr. President, members of the court, I will have to return to the legal consequences of Israel's policies and practices in the OPT in the final part of my presentation. But before I do so, I would like to conclude this part of the argument. I have established so far that Israel's policies and practices in the OPT constitute not only violation of several rules of international law, but also violation of each core element of the right to self-determination of the Palestinian people. Malaysia submits that this serious breach of a most fundamental peremptory norm of international law renders unlawful the occupation as a whole. In particular, Malaysia submits that it is the policies and practices discussed and assessed in this proceeding that constitute the occupation. These policies and practices are, in fact, the occupation itself. There are many means by which Israel enforces its control, the means by which it occupies the Palestinian territory. And they are also unlawful. They breach a great number of rules of international law and ultimately result in a serious breach of the Palestinian people's right to self-determination. This must mean that the occupation as a whole is unlawful, as it constitutes as a flagrant denial of right to self-determination. Mr. President, members of the court, I turn now to the final part of my presentation, which concerns the legal consequences arising for Israel, for all other states, and for the United Nations, respectively, out of the serious breach of the obligation to respect the self-determination of the Palestinian people. As regards the legal consequences for Israel arising from this serious breach, I will be brief. Israel must first of all cease the continuing violation. This means that it must cease all the relevant policies and practices I have already discussed. Consequently, it must withdraw immediately from the occupied Palestinian territory. Second, Israel offers assurance and guarantees of non-repetition. And third, Israel is under obligation to offer full reparation. This means that it must provide both actual and juridical restitution, including the annulment of repeal of all offending legislative and regulatory measures it has adopted for the OPT. Israel must also offer compensation for all material and moral damage caused by the breach of the right to the self-determination, to the extent that this is not made good by restitution. The legal consequences arising for Israel from its serious breach of the right to self-determination are, in principle, no more burdensome than the legal consequences arising for any state that has committed even a trivial breach of international law. Malaysia stresses the obligation. It is, I beg your pardon, it is rather for other states, indeed, for all other states that special legal consequences arise out of this serious breach of just cogence. It is for this reason that Malaysia felt it was under a duty to participate in this advisory proceeding. In particular, all states must cooperate to bring to an end, through a lawful means, the serious breach of the right to self-determination and consequently the unlawful occupation of the Palestinian territory. Further, all states must not recognize as lawful the situation created by the serious breach of the right to self-determination, that is, the occupation of the Palestinian territory. Finally, all states must not render its or assistance to Israel in maintaining the unlawful denial of the Palestinians' right to self-determination, thus the occupation of the Palestinian territory. Malaysia stresses the obligation of all states to support UNRWA and to halt any financial or military support to Israel that aids and assists in the denial of the right to self-determination and the unlawful occupation. As for the legal consequences that arise from the United Nations, these are none other than the obligation to pursue with vigor its permanent responsibility towards the question of Palestine, including its responsibility to ensure UNRWA continued effective functioning. The United Nations must continue to serve as a forum of internationalized cooperation for states working towards fulfilling their secondary obligation of bringing to an end the ongoing violation of Palestinian people's right to self-determination and the unlawful occupation of the Palestinian territory. Mr. President, Malaysia remains steadfast in our pursuit of a world where compassion and justice prevail. The principal judicial organs of the United Nations is us today. Do its part that in that noble pursuit. Malaysia sincerely hopes that it will agree to do so. Mr. President, this concludes my submission. I thank the court for its kind attention. Thank you very much.
I thank the delegation of Malaysia for its presentation. I invite the next participating delegation, Mauritius, to address the court and call upon His Excellency, Mr. Konjul, to take the floor. You have the floor, Excellency.
Mr. President, Madam Vice President, members of the court, it is an honor for me to address you on behalf of the Republic of Mauritius. Our presentation is in two parts. I will first make a general introductory statement. Professor Klein will then address you on the lessons learned from your recent HAGUE advisory opinion, in particular its relevance to the unlawful occupation of Palestinian territory and the legal consequences that follow. This matter comes before you at a time of grave human tragedy and immense suffering. As the court recognized in its recent order on provisional measures in the proceedings brought by South Africa, on 7th October 2023, Hamas and other armed groups carried out an attack in Israel, killing more than 1,200 people, injuring
thousands and abducting approximately 240 persons, many of whom continue to be held captive. Thereafter, Israel launched a large-scale military operation in Gaza by land, air, and sea, which has resulted in massive civilian casualties, extensive destruction, and the displacement of an overwhelming majority of the civilian population in Gaza. As of date of the Provisional Measure Order of 26 January 2024, the court observed that 25,700 Palestinians had been killed, including thousands of children, over 63,000 injured, 360 homes destroyed or damaged, and approximately 1.7 million civilians displaced. These stark figures, Mr. President, will only have increased and will no doubt continue to increase. It is against this somber backdrop that the court is now tasked with providing guidance to the General Assembly on matters raised in the two questions before you. The United Nations General Assembly, in particular, has exercised special responsibility over Palestine since at least 1947. In 1970, the General Assembly recognized the importance of the universal realization of the right of peoples to self-determination and condemned those governments that deny the right of self-determination of peoples recognized as being entitled to it, especially of the peoples of Palestine. The right of the Palestinian peoples to self-determination has since been repeatedly reaffirmed by the General Assembly for more than 5 decades. This is not the first time that the court has been called upon to address the right of self-determination, and in particular in relation to the Occupied Palestinian Territory. In its 2004 Wall opinion, the court observed that the rights of the Palestinian people include the right to self-determination, and this right was being severely impeded as a result of just one specific measure of the occupation, the construction of the wall to the east of the Green Line. The two questions now before the court are framed more widely. They require the court to consider the legal consequences flowing from the ongoing and increasingly severe impediments to the right of the Palestinian people to self-determination due to the prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967. Mauritius considers that through its illegal occupation, Israel has denied and continues to deny the right of the Palestinian people to self-determination. At least two legal consequences inexorably flow from this. First, Israel must cease its occupation of Palestinian territory as rapidly as possible. Second, all states and the United Nations have a duty to ensure that Israel complies with its obligation to respect the right of self-determination of the Palestinian people and to end its unlawful occupation so that the Palestinian people may exercise their right to an independent and viable state of their own. Mr. President, members of the Court, the General Assembly's grave and long-standing concern and the necessity for the Court's guidance is underscored by the unprecedented participation in these proceedings. No less than 54 states and 3 international organizations have submitted written submissions, and most of whom will be addressing the Court in these hearings. No state or organization contests the Court's jurisdiction, and an overwhelming majority consider that there are no compelling reasons for the Court to decline to answer the General Assembly's questions. Mr. President, members of the Court, as you will be acutely aware, the last advisory opinion rendered by the Court concerned the decolonization of Mauritius, and in particular, the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. From the time of its independence, more than 5 decades ago, the completion of the decolonization of Mauritius and its ability to exercise sovereignty and sovereign rights over the whole of its territory has been severely impeded as a result of the United Kingdom's unlawful occupation and administration of the Chagos Archipelago. The Court's advisory opinion delivered on 25th February 2019 concluded that, I quote, as a result of the Chagos Archipelago's unlawful detachment and its incorporation into a new colony, the process of decolonization of Mauritius was not lawfully completed when Mauritius acceded to independence in 1968. As to the legal consequences, the Court determined that the United Kingdom's continued administration of the Chagos Archipelago constitutes a wrongful act entailing the international responsibility of that state, and that the United Kingdom is under an obligation to bring an end to its administration of the Chagos Archipelago as rapidly as possible. Mr. President, the Court's 2019 advisory opinion made a significant, immediate, and irreversible impact. Less than 3 months later, on 22 May 2019, the General Assembly, by an overwhelming majority, adopted Resolution 73/295, welcoming and affirming the findings of the Court and demanding compliance with them. Less than 2 years later, on 28 January 2021, a special chamber of the International Tribunal for the Law of the Sea, in the proceedings on maritime delimitation between Mauritius and Maldives, affirmed that judicial determinations made by the Court in an advisory opinion carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law. Accordingly, the Special Chamber held that the Court's 2019 advisory opinion has legal effect, and it duly gave effect to the Court's determination that the Chagos Archipelago forms an integral part of the territory of Mauritius. Thereafter, in November 22, Mauritius and the United Kingdom decided to begin negotiations on the exercise of sovereignty over the Chagos Archipelago. While these negotiations are still ongoing, Mauritius remains confident that they will conclude successfully and that the United Kingdom will, as a result, bring itself into compliance with its international obligations, as elucidated by the Court in its advisory opinion. Similarly, Mr. President, Mauritius is confident that your advisory opinion in this case can likewise make a significant, immediate, and irreversible impact with respect to the right of the Palestinian people to self-determination. To those who suggest that the issuance of an advisory opinion might somehow prejudice the prospects of a negotiation, Mauritius underscores that, to the contrary, the Court's clarification of the legal rights and obligations of the parties facilitates rather than obstructs a good faith negotiation. Professor Klein will have more to say about this. We have utmost faith that the Court, as the principal judicial organ of the United Nations and guardian of international rules-based order, will carry out its judicial function without fear or favor. Mr. President, distinguished members of the Court, let me conclude by reiterating that Mauritius has consistently supported the two-state solution in view of its potential to bring lasting peace and stability to the Middle East region. Indeed, it is the only solution that could bring lasting peace. We believe that the Palestinians must be able to live in freedom and in their own state. We also firmly believe that the Palestinian that Palestine possesses all the necessary attributes to be recognized as a state. Mauritius has indeed already recognized it as such. Thank you, Mr. President. May I now request you to kindly invite Professor Klein to the podium. Thank you.
I thank His Excellency Mr. Konjoul. J'invite maintenant.
I now call Professor Pierre Klein to the podium. Sir, you have the floor.
Thank you, Mr. President. Distinguished members of the Court, it's an honor for me to address you today on behalf of the Republic of Mauritius. As Ambassador Kunjul has just set out, the questions that were put to you by the General Assembly have profound resonance for Mauritius. They present close links with the Chagos case. The same fundamental questions are at issue in both cases. They're both characterized by prolonged occupations of territories in violation of the right of peoples to self-determination. I should therefore like to discuss with you three parallels that can be established between these proceedings and the Chagos case. I'll begin by focusing on the limitations to the court exercising its advisory competence, limits which, in the eyes of some, might result from the existence of a negotiating process between Israel and Palestine. And then I'll briefly discuss the fact that we're dealing here with a prolonged occupation and the confusion made by some participants to the proceedings between the respective spokes of application of the jus in bello and jus contra bellum. Lastly, I'll end by briefly touching on the legal consequences of the occupation and more specifically of Israel's duty to put an end to that as rapidly as possible. Mr. President, members of the Court, some participants to these proceedings are of the view that the court should either refrain fully from responding to the request for an opinion or rather provide a limited response. This reservation, according to them, would be justified by the fact that it would undermine negotiations between Israel and Palestine or would deprive them of their effect. According to this point of view, the opinion the court might render in response to the questions put to it might run the risk of delegitimizing the legal framework established to manage the complex, as well as all prospect of future negotiations between Israelis and Palestinians. Mr. President, the Republic of Mauritius in no way seeks to impugn the fact that negotiations which the parties to the Israeli-Palestinian conflict have undertaken to conduct constitute the sole viable path to peace. This process is the only way of reaching a two-state solution, a goal to which the Republic of Mauritius remains profoundly committed, as Ambassador Kunjul has just recalled. Mauritius would rather draw your attention today to the fact that a judicial process such as this one and negotiations are in no way incompatible. Quite the contrary. Mauritius's recent experience in the Chagos archipelago case demonstrates this strikingly. There's perhaps no need to remind you that this case was totally deadlocked in relations between Mauritius and the United Kingdom for dozens of years. However, in less than a year between November 2022 and September 2023, the situation of the Chagos archipelago gave rise to no fewer than 6 negotiating rounds between the two states. Now, was it because the two parties were suddenly touched by divine grace? Surely not, or at least not only. Rather, what proved crucial was obviously the advisory opinion that you rendered in February 2019, as well as the follow-up to this opinion, in particular by the International Tribunal of the Law of the Sea, to which Ambassador Kunjul has just made reference, by concluding that the process of decolonization of Mauritius had not been completed, the court clarified the legal situation existing between the parties. The 2019 opinion and its consequences plainly played a key role in convincing the British authorities to at last embark on the road to negotiations on the exercise of sovereignty over the Chagos archipelago. And it's of particular interest to note that when the UK Foreign Secretary refers to these negotiations, he does so by pointing out that they take into account the recent international judicial decisions, and they are conducted with a view to reaching, and I quote, an agreement on the basis of international law, end of quote. The GA is asking for nothing more today. It plainly seeks in no way to obstruct future negotiations. However, it is committed to ensuring that any such process be clearly framed in law by ensuring that the legal situation of the parties is here also clarified. As noted by one of the members of the court in the Wald case, the discharge of international obligations, including urba omnes obligations, cannot be made conditional upon negotiations, end of quote. This finding remains as true today as it was 20 years ago. The court, in responding to the present request in all its aspects, will simply outline the legal framework in which negotiations will take place. But this negotiating framework is essential because it'll set out the negotiating issues that are acceptable or not. Allow me to add a final word on the question of discretionary power. Some participants to these proceedings believe that the court, were it to respond to all the questions put to it, would risk circumventing the cardinal requirement of consent to the jurisdictional settlement of disputes. That would indeed be the case were it to rule on the status of territories that lie at the heart of the Israeli-Palestinian dispute, or even on the borders at stake. The same argument was raised in the Chagos case. For some, it was a bilateral territorial dispute in which the court had no standing to intervene in an advisory proceeding. The court clearly discarded that argument in its 2019 opinion. It noted, I quote, the General Assembly has not sought the court's opinion to resolve a territorial dispute between two states, end of quote. The purpose of the request of the GA was to obtain the court's assistance so it may be guided in the discharge of its function relating to the decolonization of Mauritius, end of quote. The situation is no different today. You're in no way called upon to rule on a territorial dispute, and even less to decide on matters of border delineation. The GA only seeks here to receive your assistance in guiding it in the discharge of its function pertaining to the achievement by the Palestinian people of its right to self-determination. Therefore, no reason for the court to decline to exercise its competence in respect of all or part of the questions put to it. If we now turn to the substantive questions, there exists another striking parallel between the situation of the Chagos archipelago and that of the Palestinian territories. In both cases, these territories are the subject of long-lasting occupation. Now, this distinctive feature has prompted discussions and debate as part of the present procedure. Some of the participating states in this regard defended the idea according to which the legal status of the occupier results from the sole fact of occupation without said status being affected by the prolonged character or not of the occupation. Under this approach, one should consider the question of the lawfulness of the acts of the occupier under the sole angle of the law of armed conflict. However, the court could not rule on the question as to whether Israeli occupation is itself lawful, because such a founding would be groundless under international law. Now, I think many of us this week would have found this argument surprising. It arises from a major confusion between the rules of jus in bello and those of jus contra bellum. Yes, the rights and duties of the occupier in respect to the populations in the occupied territories are defined by the rules of international humanitarian law. But does that justify ipso facto the very presence of the occupier on the territory in question, presence in respect of which international law would be, as it were, neutral if we were to believe the argument that I've just outlined? Clearly no, because this question is part of another corpus of rules, not those of the jus in bello, but truly those of the jus contra bellum that govern the lawfulness of the use of force in the international legal order. Even if the armed forces of occupying power were to behave in a manner fully consistent with the right of occupation, their presence in the occupied territory would be unlawful if it results from the use of force contrary to international law or an act of annexation. The principle was recalled with pellucid clarity by many participants to these proceedings. To quote from France's submission, the status of an occupying power confers absolutely no legal title justifying an annexation, end of quote. And as to the passage of time, if it has no bearing on the status of occupying power under the law of armed conflict, nor can it render lawful an occupation of territory contrary to international law. The confusion between the respective scopes of jus in bello and jus contra bellum simply makes the terms of the debate less clear. To consider the situation of the OPT from the angle of jus in bello would amount to totally ignoring the fact that the situation is contrary to the principle of the rights of people to self-determination and fundamental international order, rules relating to the use of force. The Republic of Mauritius has no doubt to the fact that the court will seek to reaffirm the relevance of these fundamental principles. This brings me to the final point in my presentation, that's to say the question of the consequences of the prolonged occupation of Palestinian territories by Israel. In this regard, once again, the lessons from the opinion on the Chagos archipelago could not be clearer. According to the 2019 opinion, maintaining the administration of the Chagos archipelago by the UK in violation of the people's right to self-determination constitute, I quote, an unlawful act of a continuing character. And so the court states the United Kingdom is under obligation to bring an end to its administration of the Chagos archipelago as rapidly as possible, thereby enabling Mauritius to complete the decolonization of a territory in a manner consistent with the right of peoples to self-determination, end of quote. The same unequivocally goes for the OPT here again. Occupation is an unlawful act of a continuing character, and here again the administration of these territories by Israel must be ended as rapidly as possible in order to allow the Palestinian people to exercise its rights to self-determination. Allow me, Mr. President, to add one last point in this regard. Neither the agreements concluded between Israel and Palestine nor the possible negotiations between the parties will be able to render lawful the Israeli presence in the occupied territories. The court was confronted with a similar situation in the case of armed activities in the territory of the Congo. Uganda was seeking to justify the presence of its troops in Congolese territory by referring to several agreements reached between the belligerents aimed at, inter alia, and I quote, providing a framework to facilitate the orderly withdrawal of all foreign forces to create a stable and secure environment, end of quote. But the court clearly dismissed this argument. It noted, and forgive you for the length of this quote, but it seems to me to be of particular relevance in the context of today's, I quote, the arrangements made at Lusaka to progress towards withdrawal of foreign forces and an eventual peace with security for all concerns were directed at the factors on the ground and at the reality of an unstable political and security situation. The provisions of the Lusaka Agreement thus represented an agreed modus operandi for the parties. They stipulated how the parties should move forward. They did not purport to qualify the Ugandan military presence in legal terms, end of quote. And the court ends by ultimately concluding none of these elements, I quote, purports generally to determine that Ugandan forces had been legally present on the territory of the DRC, end of quote. The situation is exactly the same as this case. The peace process between Israel and Palestine, whatever its vagaries, is aimed at ultimately reaching a peace that guarantees security for all and allow the parties to move forward. For all that, none of these elements makes lawful the Israeli presence in the OPT. The existence of peace accords and a possible negotiating process in no way challenges the obligation for Israel to withdraw from these territories as rapidly as possible. I thank you, Mr. President, distinguished members of the court, for your kind attention shown to the oral submissions of the Republic of Mauritius. I wish you a very pleasant evening.
I thank the delegation of Mauritius for its presentation, which brings to a close this afternoon's hearing. The court will meet again tomorrow morning at 10 a.m. to hear Namibia, Norway, Oman, Pakistan, Indonesia, and Qatar. The sitting is adjourned.
The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure our voices are heard. Donate today at support.islamchannel.tv. The mainstream media has been justifying genocide in Gaza. Islamophobia and censorship are the norm. We're changing that. Our journalism has reached over 300 million impressions on social media since October 7th. On TV, our rolling news coverage has featured key figures like Hussam Zomlot, Avi Shlaim, Gideon Levy, and Jeremy Corbyn. We need your support to reveal the truth and ensure